So today we're here to discuss the issue of ransomware and the topic of paying ransomware specifically, and what kind of risks may be involved in paying ransomware in the context and background of the Department of Treasury's most recent guidelines with respect to the payment of ransomware. First, before introducing our two speakers to you, I want to just let you know that there is a chat that you can submit questions to while the recording is being played. And there'll be a live session in which the speakers will be able to answer those questions. So I suggest and offer that up to you as you listen to please submit your questions. So good day, good afternoon. My name is Catherine Lotriante. I'm a professor at Georgetown University and also work at the Center for, so it's CSIS in Washington, DC, a think tank in DC. Today, I'm happy to introduce to you two gentlemen who will be discussing this very important and also timely topic about ransomware. First, we have today with us Adam Hickey. Adam is a Deputy Assistant Attorney General at the National Security Division at the Department of Justice. At the Department of Justice, he oversees both counterintelligence and export control, this section, and the foreign investment review section at DOJ. Among other things, he supervises investigations and prosecutions of foreign, state-sponsored computer intrusions and attacks, the enforcement of the Foreign Agents Registration Act, or FARA, and the National Security Division's Foreign Investment Security Reviews. For example, how CFIUS works. We also have Stuart Baker. Stuart is a partner in the Washington, DC office of Steptoe & Johnson. He served as general counsel at the National Security Agency and assistant secretary for policy at the Department of Homeland Security. At DHS, he was responsible for policy analysis across the department, as well as for the department's international affairs, strategic planning, and relationships with law enforcement and public advisory committees. With that introduction, I'd like to offer an opportunity for both Stuart and Adam. And then let's begin with Adam. Adam, I'm hoping that you can kind of lay the groundwork, giving us some background on the Department of Treasury's guidance on the payment of ransomware, recognizing that you're not at Treasury Department, but as the government official, current government official in this discussion, I think you can lend some insight as to what the guideline says and what it means for people both in companies that may be victims of ransomware or others in the community that might have some involvement in ransomware.
Sure, happy to. And good morning to you, at least as we're recording this. Thanks for having me on the panel. And Stuart, great to see you again. I'm looking forward to this. I think it's going to be a lively and challenging conversation, at least for me. And to our audience, thanks for tuning in. So just to set the baseline or lay a foundation for the conversation, in October 2020, Treasury issued an advisory on potential sanctions risks for facilitating ransomware payments. And I'm going to summarize it briefly. Essentially, it reminds its audience that if you engage in transactions with a sanctioned entity or person, you can be civilly liable. And Treasury has the authority to bring an enforcement action, even if you didn't know that's what you're doing. It's a strict liability standard. And that includes 4 ransomware actors or groups of actors that have been designated in recent years. Since 2016, Treasury has designated CryptoLocker, SamSam, WannaCry 2.0, and Drydex under their authority, some of which are related to Iran and North Korean sanctions authorities, and some of which relate to EO 13694 and its revisions, which I'll refer to collectively as the Cyber EO. What the advisory does is it reminds readers of that authority to bring a civil enforcement action, and also the factors that will affect Treasury's judgment about whether an enforcement action or penalty is appropriate, including whether the American company or entity had a risk-based compliance program in place designed to identify and mitigate sanctions risk so that such payments weren't made. And whether the entity or victim, in this case, if we're talking about the context of ransomware, cooperated with law enforcement, reached out to law enforcement, and was transparent with them, which is described as a significant mitigating factor. Now, if you ask OFAC, they will tell you that this guidance isn't news, that all it does is summarize the law that has long existed. And, Dridex, I think, was relatively recent. Some of the other sanctions related to ransomware date back some years, I think, back to 2016. But I think when the advisory did land, when it became public, it was a bit of an attention-getting signal because some thought it was a way of targeting ransomware victims and saying, you shouldn't pay a ransom if you have ransomware, and if you do, we're going to come get you. If you read the advisory, though, the audience that it's geared towards is not the victim of ransomware so much as the intermediaries that a victim might rely on to make a ransomware payment or might do business with in responding to an intrusion. And there I'm thinking of forensic firms and insurance companies and to some extent financial services firms. And I think the point of the advisory is to go to those intermediaries, get their attention, and ensure they have risk-based compliance programs so that if they're helping a client deal with a ransomware incident and there are indications that a payment might benefit or involve a sanctioned entity or person, those intermediaries deflect the payment, prevent it from taking place. Now you might ask, why do this? If you get hit by ransomware, it's a very stressful day for the victim, right? It may be that they don't have adequate backups. It might be that the backups themselves were compromised by the ransomware. There may not be much of a choice. So doesn't this make a hard day worse for that particular victim? That's probably right if you look at it only from that victim's perspective. But ransomware is the classic tragedy of the commons, where as an individual entity, you may or may not be better off paying the ransom. But all of us are worse off if you do, because every dollar that goes to the ransomware operator or designer expands the market for it. It makes it more profitable. It ensures that there'll be more ransomware in the future. And it's even worse if it's North Korea or Iran that's in the background sponsoring the ransomware, right? Because the funds don't just further criminal goals, they can be tied to nuclear proliferation or terrorism. So that, I think, is the policy case for reminding those intermediaries like insurance companies of the sanctions authority and the impact. And the hope, I think, is that by shrinking rewards from ransomware payments, you potentially shape the behavior of ransomware actors and constrain the market for it in a way that benefits all of us. I'll stop there.
Stuart, can you give us your take, having carefully looked at the guidance? I know it's not been out that long, and as Adam rightly pointed out, maybe it's not new news. In other words, it's kind of this was based on already authorities. But what's your take looking at the broader picture? Is this useful? Do you anticipate a change in the behavior, well, of those conducting the cyber attacks, but more specifically, those that are the victims of the ransomware?
So I think this is not new for people who practice law in front of OFAC and who do sanctions law. None of the principles that were laid out are at all surprising to people who do that. But it's completely new in the context of ransomware payments, where people had only begun to think about this, and mainly to think about it in terms of the liability of the company that was the victim of the attack. It's the one place where I might disagree with Adam. It's true that this is aimed in substantial part at the facilitators of payments, but before it was aimed at the facilitators, it was aimed at the victims of ransomware. If you pay it, you are clearly subject to liability under OFAC if you pay it to somebody who's subject to sanctions. What is mildly novel as a factual matter is that the Treasury is calling out the people who negotiate these things, the people who do the forensics and say, we think that this is an okay payment or not an okay payment based on the evidence from the attack, the insurance companies that say, yes, we'll cover you for this, and maybe the financial services people who actually move the money. Those folks probably had not, because they didn't have a reason to understand the details of OFAC law, didn't understand that facilitating a payment that violates OFAC sanctions is itself a violation of the sanctions. And that's clear enough as a matter of law. It probably was a surprise to the people who do this to some degree, depending on how much legal advice they got before they did this. This is probably, and I think it's worth saying that there was in August, 2 or 3 months before this came out, a very notorious ransomware attack on Garmin. And Garmin, everyone surmises, I'm not sure they've confirmed this, paid the ransom, got their data back. And not long thereafter, RETE, which does forensics, announced that it had decided that the particular kind of ransomware that was used to attack Garmin, though they mentioned Garmin not at all, was not necessarily Evil Corp, which was subject to sanctions. So there was it was a controversial analysis, but it was a public analysis, and it was widely viewed as a justification for Garmin to pay and for others to pay if they were subject to wasted locker attacks. And it's not unreasonable to view what Treasury did as an effort to make sure that people who stepped into this gray zone understood that they were taking the risk, that if they were wrong, they had violated the law. The fact that they didn't know for sure they were wrong doesn't matter. If Treasury later finds that you made a payment to somebody who's subject to sanctions, all the goodwill and all the reasonable precautions in the world don't prevent you from being held to have violated the law. All they will do is reduce the level of sanctions, and the advisory gives us a couple of practical tips for ways to reduce your likelihood of liability, which are also designed to say, don't get too cute with your attributions, because we're going to be watching, and if we don't think you did it in good faith, if you didn't do it pursuant to a careful compliance plan, we're going to hammer you.
So can I, if I could follow up with both of you on that. First to Stuart, the list of intermediaries that you discussed as potentially being very much affected by this, could you throw in law firms in that too? I mean, those that are.
So yeah, they did not include law firms, and I suspect that was a careful decision. But I have advised plenty of American general counsels or associate general counsels working in foreign firms, that they can be subject to facilitation liability if they are not careful about the advice they give. There's a little more leeway because you can give compliance advice and not be guilty of facilitation. So that may be why they left law firms out. But yeah, I think law firms that are too cute here and develop a reputation for a good law firm to go to if you want cute advice are probably at risk.
So if that takeaway from this, could it be, and Adam and Stuart, I'd like to get both your views, but maybe Adam first on this, is one, if I'm reading this and I'm a victim, but not a lawyer, haven't consulted lawyers, but I'm reading this guideline, the new guidelines, trying to understand the state of things and have been a victim, is one takeaway, is it recommended that the first call is to FBI? I mean, does that help? Does that help a potential entity that's been a victim who wants to pay, right? What benefit is there? And should they call the FBI? How does that help them?
So the answer to that question will always be yes, from my perspective. You should call the FBI ransomware or not. But it will help in this specific context too. I think if you're the victim and you've been hit with ransomware, you're probably not reading Treasury guidance that day. You probably called if you have them on retainer or you referred to someone, you call an incident responder. Your network's not locked. And if your IT department can't do it, you need to restore from backup, or you need to figure out what's going on. Maybe you don't call them, maybe you try to make the payment yourself. But I think at some point you're gonna hit your insurance company, a forensic firm, or some other, I'll call them an intermediary or a facilitator, with Stuart's word. They hopefully will have read this advisory. And then in the course of the response, they will say, well, this might be a Dridex variant, and so we can't help you make this payment. At what point you call the FBI, maybe you call them the minute your system's locked, maybe you call them after you called your lawyer, your insurance company, and your forensic firm. At that point, FBI might be able to help you understand better what variant it is. They might tell you with greater clarity that it's not a sanctioned variant, that actually it looks different, it looks like a false flag, or they might tell you, confirm what your others have said, which is, yeah, we're not sure. There are indications this is a such and such ransomware and that's been designated. That does make it harder for you to pay. But let's take another example where no one's seen this before. It's a new variant. There's not a lot of information out on the internet about who's responsible for it. You've called the FBI. No one tells you this is a sanctioned entity. You make the payment. And 6 months later, it turns out that this was Dridex 3.0. But you didn't know that. And let's say it's public because you're a large company. So the fact you paid the ransom, it becomes known. The benefit of having called the FBI is that if Treasury reads the newspaper that you paid the ransom and they know that it happened to be a sanctioned entity, the fact you called the FBI and involved them in a certain way in your decision-making will be a significant mitigating factor. And I'm not aware of any circumstance where someone has done that, where we, the Justice Department, have come after them criminally or Treasury has imposed a penalty. I think, this is a hard, I don't know if this is intuitive, but I really do think the point of the advisory is to get people to design programs to detect risk and to not make the payment. It really doesn't work as a policy matter just to go after people after making the payment. That's not the goal. The goal is frankly to make it unpalatable to you to make the payment, or at least to make it difficult for you to do so because no one will help you make the payment. And I think, echoing Stuart's point, I think, if there were to be a firm that says, well, we're gonna turn a blind eye to this and develop policies and sort of help victims out. We feel really, let's say it's called Empathy Corp instead of Evil Corp. We really feel bad for ransomware victims. So you can come to us and we will tell you no matter what, this is not sanctioned ransomware. We don't see any indication of that. Well, at some point, we, the Justice Department, will probably catch on to this, and that will take you from being a strictly liable entity to an entity that's behaving with at least conscious avoidance of the facts, if not in criminal intent. And that will expose that intermediary to prosecution. So I think that's the way to think of the chain of behavior we're trying to encourage is if you create policies that will prevent the payments, we're less interested in the one or two that slip by because the compliance program maybe just doesn't catch everything. But if you haven't designed that program, in fact, you've done the opposite to try to facilitate these payments, then you're exposed to a much more significant sanction.
Yeah, I think victims of ransomware are going to find that most of the intermediaries have been pretty thoroughly deterred from offering close to the line advice on this, because from their point of view, what they make for one engagement is simply not enough to justify a large risk of an investigation and substantial penalties under the OFAC regime. So your insurance company is certainly not going to want to assure you that it will cover your payments if it thinks there's a risk that it's a sanctioned entity. And probably that's true for the forensics and the negotiators that you might hire to try to arrive at a suitable ransom. So this probably is having the effect that was intended, which is to make it harder to make payments to people who are reasonably believed to be subject to sanctions. I do think there is a question whether that makes sense. OFAC's rules were originally designed to impose penalties on, Nazi Germany while we were at war with them, and the same in World War I. It is a nuclear weapon, and the penalties are enormous, and the structure is designed to make sure people stay well away from anybody who's a sanctioned entity. But we have begun using it in a very fine-tuned way. The US government has begun using it, person by person to cut people off from the banking systems. And it has worked to some degree in that context. But in this context where people are really up against it, it really does simply add to the pain the victim suffers. And I'm not sure it's really going to affect the people who are serving ransomware. There's no indication that I've seen that they are hiding their old protocols and tools and techniques in an effort to make it easier for people to decide that this is really not Evil Corp and so I can pay them. If they're not even doing that, then they're not really very deterred by the imposition of sanctions. And the only people who are suffering are the companies that are subjected to a second risk of liability if they pay.
So coming up, Stuart, if it ends up being that the effect is that these intermediaries are deterred then, and they're not going to be giving any advice that they might otherwise have been given to these victims, where are we leaving the victims then? Those that feel that they need to pay this ransomware, they don't have backups, for whatever reason, they've made a determination for their own interest, for their company, they're going to have to pay this ransom. Is that going to deter them? And I would like to see, do we have any idea of how this looks globally? Are we then putting American entities in a situation where, as you said, if the bad guys are going to continue to conduct these attacks and maybe look elsewhere outside the United States if they're not getting their money here, how are we placing our American companies vis-a-vis others that might not be under the same restrictions or Department of Treasury guidelines?
If it was working, then we would see ransomware gangs avoiding American companies or companies with substantial US assets because they thought it was going to be harder to get paid. And then they would pick on others. And it's a variant of what we have seen, I think, in the area of terrorist hostage taking, where the US very hard line until fairly recently has made it unproductive to kidnap Americans for ransom. If you happen to kidnap them, it's probably more likely you'll kill them than that you will hold them for ransom, because the U.S. has been so tough on ransom payments, and that has exposed other Western countries to more kidnappings than Americans. So it could work, but I don't see a sign that it is having that effect, which makes me think that maybe these sanctions aren't really biting for the ransomware gangs.
So I think it's a little, the difficulty with measuring the effect of the policies, it's inherently going to involve unknowns. Remember that not all ransomware payments are subject to sanctions, right? It's only payments to sanctioned entities, of which there are 4 clusters or groups. So one interesting question is, what's the impact on ransomware creators or operators who are not yet sanctioned? And do they shape their behavior in any way, knowing that if they become the worst of the worst, to sort of colloquialize the standard for sanctions under IEEPA, right? A threat to national security or economic interest. They get put on this list, and it makes it that much harder for them to move money. It cuts off their access a bit. Do they then try to stay below that threshold? Does that mean it's better to be, when the bear is chasing you, you don't have to outrun the bear, you just have to outrun the person running next to you? So by that logic, are you better being a little quieter, a little less ambitious, and therefore victimizing fewer Americans, or focusing more on Western Europe? I can't answer that, but there's a certain logic to that driving, that decision calculus. And to your question, Catherine, about the victim that has to pay, that feels like a compelling case, but frame it in terms of paying money to Iran, right? I mean, or to a terrorist organization. Yes, it's awful if your relative or your business is held hostage by a terrorist group, but we are all much worse off if you give them even more money to encourage this behavior, to the point about hostage taking. So fortunately, there are ways victims can protect themselves to some great degree from ransomware, and it's some of the concepts Stuart mentioned, like backups and the like. And to take Treasury's position, just because you didn't take the right steps to prevent or mitigate harm to your network doesn't mean the rest of us should have to contend with a richer North Korea or Iran.
Thank you for your thoughts on that both. I wanted to, it's not completely unrelated, but it's tangential to the guidelines. I wanted to see if we could say or get your opinions on kind of some general efforts, or maybe even specific efforts from the government and others with respect to the release of private emails. I mean, it's not necessarily ransomware, but I think this is an important thing in which maybe some of the same victims of ransomware would be very concerned about emails being released out there, and what the government, DOJ, FBI, or others could do maybe to assist these individuals in this. I'd love to hear from both of you. Maybe Adam, you can start with the perspective from what the government might be able to do, and Stuart, maybe some views at how effective this could be and useful it might be.
Sure, happy to. And it's a logical segue from this, because as you probably know, ransomware operators are now turning to extortion. If the victim says, well, I'm not going to pay you, I have backups, whatever, the next move might be to say, well, great, you have the emails, but so do I, and I can release them. And what do you think about that? So you're seeing a blending from ransomware into extortion. This isn't new, right? The first time I saw this was in the attack on Sony Pictures Entertainment in, I think it was about 2014, where in addition to bricking the company's network, the actors, North Koreans in this case, did dump a lot of the material on the web at various locations around the world. One of the benefits of working with the FBI and the Justice Department is our network of contacts with law enforcement around the world. And so while a lot of that data, most of it wasn't hosted here, it was hosted on systems around the world, we were able to reach out through law enforcement liaison relationships and ask the authorities in those countries to use whatever authorities they have to try to mitigate that. And here, if it's hosted here, although you tend not to see that quite as much, we would go to the providers, alert them to what they're doing. And in the case of a sanctioned entity, if you're providing server space to North Korea or Iran here, and we tell you that's what you're doing, and you don't stop the transaction, don't stop providing that, you then become potentially exposed to a penalty, right, under the same authority. Because you're, imagine the ransomware operator that's also leased the DC Leaks site here, right? That's you're doing business with them. So that is one way the government can also help mitigate the harm to the company. It's not perfect, right? Once it's on the internet, it's on the internet. But there's a difference between how widely accessible, difference in impact depending on how widely accessible the material is. So that's another reason to call the FBI, I think, is that we can be helpful in that respect.
Stuart, so do we have a silver lining in calling the FBI? I mean, do we see some advantages?
So there is clearly that the Treasury has made it absolutely clear. You bring in law enforcement. It doesn't have to be the FBI. It could be the Secret Service. It could be ICE. It could probably be local law enforcement. And you make a full disclosure, a timely disclosure to them. Interestingly, they did not ask that you ask law enforcement whether it's okay to pay. So you might be able to tell them, I'm going to pay. I wanted to bring you in and tell you all this stuff because it's part of my compliance plan, but I'm paying. So that's a possibility. Getting back to the doxing, the hacking and releasing of data, I think there are options to consider. Ever since it, frankly, an operation like that cost Hillary Clinton the presidency, Silicon Valley has been much less enthusiastic about WikiLeaks and Julian Assange and the like. They probably would be open to refusing to allow the distribution of hacked materials. Some of the companies say it's a violation of their terms of service. One thing I've often wanted to try is nobody carries, if they can avoid it, copyrighted materials. It turns out that all of our emails are copyrighted as we write them. And so if you were to find a way to register copyright for at least some of the emails that might end up being released, you'd have very powerful sanctions on secondary distribution of those documents. It's probably worth considering if you think you're likely to be a target, although I will confess this is an idea that has occurred to me as we were speaking, so there may be a legal problem with it, but it's worth considering.
Oh,
Well,
that's
the
interesting.
problematic emails are probably not the ones you're going to rush to copyright, but I think reaching back 20 years, the copyright right vests as you fix it in a tangible form. So I don't know that you have to actually register it to have some of the protections.
That's right. It is already copyrighted, but to get the benefit of the hammer of $250,000 for every publication, you need to have registered it. And you don't have to register your scary ones. If no one is going to go through and only release the scary ones, they're just going to dump the whole thing. And you just say, as long as I have a few canaries in there that can announce that the whole coal mine is going down, it may be enough.
This is why you get paid the big bucks, Stuart.
So that's something new, actually. That's a good takeaway. And I think that we've given some potentially many people in the audience some food for thought. They may be calling their or asking their in-house counsel about copywriting emails. I think I myself would consider that, especially if I was a CEO of a company. I might think about that. I think we're coming up close to our time limit, but I wanted to ask both of you for any concluding comments or advice that you wanted to share, anything you wanted to highlight or emphasize or take away for folks to remember from the session.
You know, I just say that I think a common theme is that you're better off calling law enforcement and working with us. I mean, there's a temptation to avoid being pregnant with knowledge, but the system isn't built to reward that. And, you know, even if you think paying the ransom is your only option, it could leave you less secure in the future because there's no guarantee that that actor is going to pull every tool they have off your network. If you pay once, why wouldn't you pay again? And it leaves you vulnerable to being exploited a second time.
And Stuart?
So the OFAC sanctions are a nuclear weapon, and you don't use those to get rid of the cockroaches in your home. And that's the worry here. I would say if there's a lesson here for business, it's that we shouldn't be applauding when the Treasury announces that they are imposing sanctions on another ransomware entity. Unless we know it works, because if they impose the sanctions and it doesn't work, it's really just imposing sanctions on the businesses that are victims, and we need to be much more careful about that.
So before we wrap up, to the point of when will we know what it will look like if it's working? I think, Stuart, you've kind of outlined that. Adam, you did too. How long will this take? Do you suggest? just, it's a big hypothetical, I guess. We know ransomware is probably not going to, in the near future, doesn't look like they're slowing down. But will this take a year before we can come back and say, oh, these guidelines look like they're working? Or is this a longer term? Do we have to wait longer in which to get a good assessment of effectiveness, do you think?
I think in terms of discouraging payments, I think we agree it's working. And so that, by that measure, it is a success, right? We think it's already slowing or stopping payments to designated entities. If your measure is it working in bankrupting the ransomware operators? No. And I don't know that we will ever know that. We'll never know how much more they would have made. We won't ever know what the other unsanctioned operators are doing differently. So I think it sets up a burden we can't carry if you frame it that way. But if you think about kidnapping by terrorist groups or the like, we all agree it's better that they don't have resources. And so if we agree that discouraging the payment of resources just gives them less access to ransomware, we know they're not getting an extra 250 Bitcoin or 1,000 Bitcoin, then it's working.
So I don't think this is going to work by itself ever. We are going to have to find other ways to sanction and impose difficulties on ransomware gangs. Maybe, it's clearly cryptocurrency that has made this an easy reward for ransomware gangs, and finding ways to track and discourage illicit use of cryptocurrency is really critical. And then finding other ways to discourage the havens for the ransomware. Maybe if we could persuade Vladimir Putin that he's been the victim of Drydex, that gang will find no refuge in Russia. But we're going to have to continue to work on this. This is a feel-good solution for the U.S. government rather than a real solution to the problem.
So maybe step number one, but it does sound like what Stuart, at least what you're calling for, and I don't think Adam would be opposed to more creative thinking, that we probably do have to, it's not only Treasury departments or even law enforcement role, but maybe even broader thinking about what else can be done. So with that, maybe we wrap it up, and might have to be back on this topic to discuss what progress we're seeing or more creative ways to tackle the issue. But I want to thank you very much, Adam and Stuart, for taking the time